Welcome everybody, welcome again. My name is Dan Rudderow. I'm an attorney and I've been practicing law in California now for over 25 years. Our law firm over here in Orange County primarily represents the owners and managers of mobile home park communities as well as recreational vehicle RV parks. We have at our firm attorneys that prepare rental agreements, park rules, various other residency documents for our communities. Our firm also handles evictions, and we also represent park owners and managers in a variety of different types of litigation cases. At our last webinar, the participants who attended expressed a lot of interest in having a webinar done on how to correctly go about evicting a homeowner, not based on non-payment of rent, but based on the other grounds available to us for one, when the homeowner doesn't follow the park rules, or two, when the homeowner causes a substantial annoyance to other homeowners and residents. So by popular demand, we thought we would make that the topic of today's webinar. Starting, I guess, at this point and going forward, this webinar should take about 45 minutes. During the webinar, you can submit written questions by clicking the Q&A. Time permitting, I'll try to go through some of your questions at the end, if there are any. Even if your question is not answered, or if you think of a question after we get offline here, feel free to email me with your questions and I'll get you back a response. My email address is dan@rudderowlaw.com. Okay, so let's get started. So the first slide I wanted to start with is, why are we here? Why is this seminar important? This is a seminar about trying to have a discussion about how to properly prepare our 7-day notices and other eviction notices. Generally speaking, evictions do cost money. They usually cost money in terms of hiring a law firm to prosecute that eviction through the court system. And where the park manager or the park owner has done a great job of correctly preparing and serving an eviction notice, those type of cases are going to be obviously easier for the attorney because everything's in perfect order in terms of preparing the file and going to court. And generally, the eviction process in court should go smoother and it should go faster. On the other hand, and we've all been there, we've all made mistakes, but on the other hand, when there's a problem and for whatever reason, perhaps a park manager forgot to correctly prepare some eviction notice, that problem or defect in the eviction notice could be a problem in court. It could possibly cause the landlord or the park community not to prevail in court. Most times though, what I see happen is when notices are not prepared correctly, I see that the lawyers need to spend more time in court. And they spend more time in court because they have to take more time with the judge trying to explain to the judge why some mistake or typo on an eviction notice is minor and should be inconsequential to the outcome of the case. So the bottom line here is that if we have park managers and park owners preparing better, more correct, if that's a word, notices, it makes the eviction process go faster. And when the eviction process goes faster without issues, it reduces the amount of attorney fees. So our discussion here and what you're trying to learn and how you're trying to learn to do your job correctly, really in the long run, it does affect the community's bottom line. My IT technician, Megan, she does a great job of putting together cartoons for us. I just let her have carte blanche, and I think this is supposed to be her first cartoon she came up with, where she was going to, I think I think the gentleman in the glasses is supposed to be the park manager, and then the guy in the green shirt, I think he's supposed to be our happy homeowner, because this is trying to explain to the homeowner that maybe they're not complying with our park rule. And I wanted to start with this slide because I think it's important for all of us to understand and recognize that the eviction process and hiring a lawyer, that's all sort of a process of last resort, in the sense that before we ever get to eviction, hopefully good management is such that we can get homeowners to voluntarily comply with our park rules. And this is not a webinar on good management techniques, but we see over and over and over with our clients, with different park communities that we represent, that where those park managers are very good, where they have their ear to the ground about any issues that are coming up in their community, where they are walking the park perhaps every day, maybe in the evening, where they walk around and they have conversations with their residents and have a good relationship with those residents, and, you know, compliment residents when they're doing something good and positive. If some resident has flowers that are gorgeous in front of their mobile home or RV, you know, the park manager can compliment that good job and say, hey, I just want to say to you that your flowers are gorgeous. You know, human beings get defensive, especially when they're called on the mat that they're violating some quote park rule. And generally speaking, you know, we find it's easier if that manager has maintained a good relationship with that resident and complimented that resident on their flowers, that, you know, the following day or the day after, when the park manager makes his or her rounds and now there's weeds growing up in that same flower bed, that when that park manager says to the resident, hey, again, gorgeous flowers, but, you know, if you could just clean this little problem up here with the weeds or the chip paint or, you know, leaving boxes out on the carport, you know, if there's a good relationship being maintained with that homeowner, you're probably going to get a homeowner that's less defensive. And, you know, you have a good chance of getting that homeowner to say, oh, you're right, I'm so sorry, and get compliance. And so that's obviously what we hope. We hope to get compliance in a friendly way before having to resort to the eviction process. So you will all recognize this little character from Saturday morning cartoon shows, or at least I do, because I'm over 50 years old. So this is what was on TV when I was 7 years old. I think this is Megan's favorite cartoon for the law. And I just wanted to preface today's discussion with the fact that what we're talking about is evicting people under the mobile home residency law when the person owns their mobile home and they're renting the space. In that context, that's what we're talking about today. In those situations where the park actually owns the mobile home and rents the mobile home and rents the space, then there's other landlord-tenant law that would apply. For some reason, Megan knows that I've got something about dogs on leashes. I actually tried a case about dogs on leashes in Orange County Superior Court in front of a judge with witnesses and what have you. So I keep bringing up dog on a leash, and so she keeps putting cartoons together for me like this. The challenge, and I say challenge because I have a tendency to walk around the office and call things problems and issues. And I suppose the more positive way, instead of calling something a problem, is to call it a challenge. The challenge we're talking about today is, you know, we have a homeowner who's current on the rent. But even though they're current on the rent, for whatever reason, they're not following a particular park rule or several rules, or they're causing what appears to the park manager to be, you know, causing a substantial annoyance to other homeowners and residents in the park. The problems we're talking about here run the gamut. And I'm sure you as a park manager have seen more than I've seen, although we see a lot in the files that we handle. Problems can range from everything. I mean, they can range from, walking the dog without a leash to more serious offenses involving drug dealing, fistfights, or discharging a firearm. I had a client this past weekend that had 3 residents get into a fistfight using brass knuckles. So it was pretty serious. But the bottom line is we're talking about problems and they run the gamut. Some of these problems are going to be relatively minor, then some of them are going to be more serious, and then others are going to be very, very serious. When I have a client that says they want to evict a homeowner for failing to abide by the community's rules or substantial annoyance, I do double check with the client at the time I get the file and just verify with that park manager that this person is in fact current on rent. Occasionally, even though the park manager wanted to evict them for causing a substantial annoyance, the park manager will check his or her records and say, you know what, Dan, actually they are in default on the rent. And so if that happens, you and your attorney may want to have a discussion about maybe doing the eviction based on non-payment of rent, just because non-payment of rent is a more straightforward process that judges in court understand, and you might have an easier time, a more straightforward time to get the person out of your park. And if that was because of non-payment of rent, then that's fine. If that was the easiest way of doing it, even though in the back of your mind, it was about the rent, but maybe it was about something else, about them not playing well or nice with others. So something to keep in mind. Again, the dog with a leash, and the cartoons go on. But anyway, let's talk about the first part of this 2-part seminar. The first part is evicting someone for violating the park's rules and regulations. We're talking about the law is here. I like to quote a little bit of law so that you guys can actually see what the MRL says. And we're talking about 798.56, and this is the quote out of the statute. It basically says that you may terminate a homeowner for, quote, failure of the homeowner or resident to comply with a reasonable rule or regulation of the park that is part of the rental agreement or any amendment thereto. So the first thing I want to mention is that these are your community rules and regulations, and you are trying to go into court and enforce those rules and regulations, and those will in all likelihood be enforced so long as the judge agrees with you that your particular rule or regulation is reasonable. If, because we're talking about the statute says reasonable rules and regulations being enforced, we always want to make sure that our rules are reasonable because we don't want a judge to say, counselor, I'm not going to enforce your rule because I, the judge, don't find your rule is reasonable and cite to the statute. Most of our clients who give us copies of their park rules, we find that most of their park rules are reasonable. Once in a while, there may be a rule that I kind of say to myself, is there a chance a judge, any typical judge who takes the bench in court may find this rule unreasonable? The only one that comes to mind in the last couple of years is we had a community, perhaps your community is like this, a community had a park rule that said that you're not allowed to walk your dog in the park. I mean, physically, you have to take your dog out of the park, down the street, outside of the park premises and walk the dog there. The MRL actually gives homeowners a statutory right to have at least one pet, including a dog. So when I saw this particular community rule, this is one of the rules where I might work with the resident, work with the park manager and say, is this rule kind of reasonable or is it unreasonable? I mean, if they have the right to a dog, is it unreasonable not to let them walk the dog around the park? You may have this park rule in your park rules, Does that mean your rule is invalid or, illegal or unlawful? It doesn't mean that per se. It means that, you need to discuss it with your attorney. And if you were relying on that rule and you went to court, you should evaluate whether or not you think a judge would find your rule reasonable, find that rule reasonable. Because if the judge found your rule unreasonable, the judge may decide that he or she doesn't want to enforce that rule. So the process here on rule violations, evicting someone for a rule violation, is that the law says before you serve them with the 60-day notice to terminate their tenancy, you must serve the homeowner with a written 7-day notice, and they have 7 days to comply or adhere to the park rules during those 7 days. So they're given the opportunity during those 7 days to cure the rule violation. And if they do cure the rule violation during those 7 days, then you cannot proceed with the 60-day notice, because the law requires that you prove that you served them with a 7-day notice, and during the 7 days they still failed to comply with the park rules. If you have that kind of case, then yes, after they haven't complied during the 7-day period, on day 8, you could then serve them with a 60-day notice. There's a limit to this, and the law recognizes that we don't want this to go on and on and on and be ridiculous. So there's another rule here that I've quoted, and I've given you an example at the bottom of the screen. Is what happens if you have a homeowner who is just cantankerous and keeps curing the rule violation, and then we have to serve another one, and he keeps violating and curing and violating and curing? I just give a random example. What if hypothetically you had a homeowner who was displaying a large flag or a flag that's too large and violates your park rules, in terms of you have a park rule that says your flags have to be a certain size? What if they display this large flag in violation of your park rules? What if you serve them with a 7-day notice? What if during the 7 days they take the flag down and cured the park violation? That's fine, but then what if 2 weeks later they put that same flag up there violating the same park rule, and you do another 7-day notice and they cure it within that 7 days? And what if 2 weeks later they put that flag back out there and are violating your park rule a third time, and you're having to write a third 7-day notice in which they once again cure that violation within the 7 days? What the law is saying is, at that point, we're not going to require you to do a 7-day notice anymore. So if you go through this process of within a 12-month period of having them violate a rule and you give a 7-day notice and they cure it, do that 3 times. But after 3 times of them curing the 3 7-day notices, the 4th time they put that flag out there, you're not required to serve them with a 7-day notice. You can go straight to serving them with a 60-day notice. So, whatever I say in this presentation, you should, of course, not rely upon for legal advice, because every single case is different. What we're trying to do in this webinar is we're trying to just give you an overview of what the law is, and we want to possibly point out some issues that you may have about how to solve issues with 7-day notices. So what I'm saying to you with having to serve a 60-day or not serve a 60-day, make sure you verify all this, that it applies to your particular case with your attorney. So, preparing the 7-day notice. The statute, the MRL, doesn't exactly say what has to be in the 7-day notice. It does say that it has to be in writing, but it doesn't say anything other than that. So what we tried to do is make sure that our 7-day notices look as much as possible like they are complying with the statute, because at the end of the day, we're going to have a judge in court who's going to be looking at the statute that says that we were required to give a 7-day notice. And we want to make it very easy for that judge in court. We then want to hand the court or hand the judge a copy of a document that says at the very top, 7-day notice for violating park rules and regulations. So it's important to have the word 7-day notice up there. Is it legally required? No, but I think we all understand we're trying to show a judge that we're complying with what the statute says. At the top of the 7-day notice, we also want to address it at the top to each homeowner and say it's to one or two homeowners and all residents and tenants in possession. What I would like to see is I would like you to put the name of all the homeowners on the 7-day notice and make sure their name is spelled correctly, proofreading their name off of what their name is on the signed rental agreement. And make sure you have the address correct. The question comes up with, well, what if there's a Mr. Smith and a Mrs. Smith, or a John Smith or a Mary Smith that are on the rental agreement, and only one of the homeowners is violating the park rules? You do want to put all of the homeowners who are on the rental agreement at the top of the 7-day notice and serve, for instance, in this example, both homeowners. And the reason for that is because you're going to end up evicting both homeowners in court, and the judge is going to want to see that as a prerequisite to evicting both homeowners did get a 7-day notice, even if that 7-day notice is, the contents of it is only about what the one homeowner is doing wrong. So now you've put at the top 7-day notice. You've made sure that the homeowners' names are on there, if it's Sally Smith and John Smith. You've made sure the address is correct. You've made sure their name is spelled correct by comparing it to their name on the rental agreement. Now in the body of the 7-day notice, you want to explain to the resident or the homeowner what the homeowner is doing wrong. So it's generally a good idea to specify the rule, such as saying that it's rule number 7 or rule number 10. And it's generally a good practice to write out the rule that's being violated. Occasionally, I see in clients' park rules that we're talking about a 1-sentence rule that they violated, but that one sentence is kind of smashed in the middle of this big, huge, long paragraph that has lots of other sentences. The lawyers typically don't need you to type out the entire paragraph if the other sentences in the paragraph are not applicable. So if you have a big, long paragraph and they just violated one part of that paragraph, one of those rules in the middle, then just quote that rule. So it might be something like, you have violated park rule number 7 that reads in part, dogs must be walked while on a leash. Now, after you cite the rule, like our rule is that you have to walk the dog on a leash, you have to give a brief description of how the homeowner was violating the park rules. You have to tell them what they're doing wrong. So try to give as much factual specificity as you can. Try to give as many facts as possible. Sometimes it's going to be very simple like this. I mean, sometimes it's going to be, on March 25th, 2020, you were observed walking your dog in the park without a leash on your dog. Sometimes you're going to have a more involved description about how they're violating the park rules. Clients ask me, should we take photographs? And generally speaking, taking a photograph of the problem, if you're able to do so, and attaching it to the back of the 7-day notice is a good idea. Make sure that you date stamp the photograph so the photograph has the date stamp on it. And when you're taking the photograph, don't stand on the space. So what I mean by that is, let's say you had a situation where the homeowner is hoarding and has a lot of trash and boxes all along their carport. You can stand on the street in front of the home and you can take a photograph of all these boxes that are hoarding and violating the park rule to keep the carport neat and clean, or keep the space neat and clean, without having to go onto the space. Now, I know as experienced park managers, you're saying to yourself, well, I know the law, I know when I'm allowed to come onto the space, and I would have a right to be on the space, so why are you telling me to take a photograph when I'm not on the space? I've had the issue come up in court. I've had a manager cross-examined in court by opposing counsel about where the manager was standing, and trying to get an issue going in front of the judge. It's an issue that I would prefer we just not create or have to litigate in court. I would prefer that park managers take photographs off-site or off the side of the space, so that we just simply take that issue away from the opposing counsel in court. Again, the idea is to make sure that your eviction process in court goes as smooth as possible. And so this issue arose in one of my trials. So we're just trying to point out some things that you might want to avoid, just to make the process go a lot smoother. A common issue here is, what if I, the park manager, did not observe the violation? The civil code does speak to this in this sentence here by saying that it says, and I just quote you a little bit of law, nothing in this subdivision shall relieve the management from its obligation to demonstrate that a rule or regulation has in fact been violated. So I think most lawyers believe that the judge will say that that shows that it is the management's responsibility or burden of proof to show that there was a violation if we were to get to court. And that means that, sure, it would be best if the manager observed the violation with his or her eyes, such as the park manager observed and took photographs himself or herself of the hoarding on the carport or the weeds growing in the yard. Occasionally, the manager might be relying, however, on complaints made by other residents, or maybe relying on what a police report says. So I flagged this issue, not to tell you exactly and give you legal advice as what do you do in that situation. I'm simply saying that you should discuss those issues with your attorney, because you and your attorney will want to make sure you have a really good case in court, and the judge will hear from you in court, but the judge will want to know whether or not you heard or saw things with your own eyes. And if you haven't, then that's something that needs to be planned for and prepared for in court between you and your attorney. And there are ways of doing that, and we certainly work on a lot of cases where we're evicting people based on a police report, and we have a certain way of going about that in court. So it can be done. It's just something to be mindful of. Very good idea to sign the 7-day notice. Again, the statute doesn't say what has to be in the 7-day notice, but we know that a judge is going to like seeing that it's signed. It looks more official. It looks more real, if you will. And we have an easier time getting that 7-day notice to pass muster with the judge when it looks very official and is signed by the park manager. Now, after we've prepared the 7-day notice, we have to serve the 7-day notice and fill out our proof of service. Basically, with 7-day notices, the rule is that you can serve them either by personal service, i.e. handing them the 7-day notice face-to-face, or mailing it to them in the United States, through the United States Postal Service. So what that means is what you cannot do. You can't clip it to the outside of the mailbox. You shouldn't stick it inside their mailbox, because really that's only what the post office can do. You shouldn't stick it in some type of tube that you've created above the mailbox for flyers. It's basically two things. You can hand it to them, or you can officially mail it to them. There are some other notices, like the 60-day notice, that require them to be served in a certain manner, like substitute service or post and mail. And what our park managers do is they just get used to subserve, or our park managers get used to post and mail. And very frequently, we'll have a park manager that serves the 7-day notice by post and mail. When you post and mail something, since part of that was sticking it in the mail, the United States Postal Service, the mail service, post and mail is fine. It's kind of going above and beyond what the law requires, because you're actually also posting it with respect to 7-day notices, but that's fine if you post and mail your 7-day notice. Substitute service is handing a copy to someone and then coming back to your office and putting another copy in the mail. Again, you're mailing it. So, so those methods are fine, but, and it's very common to do those methods because they're actually required with other kind of notices. If there are 2 or more homeowners that are on the rental agreement, and you have, of course, like I said, put the 2 homeowners' names at the top of the 7-day notice, I would like to see on the proof of service that you've served both homeowners. Is it fatally defective if there's 2 homeowners on the rental agreement and I only served one of the homeowners? We have arguments and we have case law that we can use in court to hopefully still be successful. But again, we would prefer not to waste time in court, and we would prefer to have a winning case that goes extremely well and extremely quick for the client. So the best practice, so that we don't raise any legal issues in front of the judge, I don't want the judge scratching his head or her head and having the judge say to me, "Counselor, you've got 2 homeowners and I only see one proof of service as to one of the homeowners." So we want to avoid that situation. So it's best to serve each homeowner with their own 7-day notice, their own copy of the 7-day notice. But you don't have to serve both of them in the same manner. For instance, you might take 2 7-day notices with you down to the mobile home and knock on the door, and the husband answers the door, and you personally serve the husband, and the wife is not home, so you end up coming back to the park office and serving the wife in the mail with her copy. So then you will probably prepare 2 proofs of service. You'll have a proof of service that you say under penalty of perjury that you served the husband by personal service. And then you'll have a separate proof of service where you say that you served the other homeowner, the wife, by mailing her her copy. Obviously correct, very important to fill out the proof of service correctly, have the homeowner's names at the top spelled correctly, identify the document that you're serving, on the proof of service, say that I served a 7-day notice or 7-day rule violation notice. Check the box accurately and correctly about how you served that 7-day notice. And then date and sign the proof of service and keep it attached to the back of the 7-day notice, because you're going to be putting that away, and then 2 or 3 weeks, maybe even a month later, you might be sending that file off to the attorney, and that attorney is going to want to see the 7-day notice, and that attorney is going to want to see the proof of service that shows how you served that 7-day notice. Another great cartoon. I think this cartoon is one of my favorites, and I think I told Megan that because she keeps putting it in all my webinars. But after we've served the 7-day notice, now we're talking about, did they comply? We got to see if they comply during the 7 days. They have 7 days to comply. So we're kind of talking about, if you personally handed someone a 7-day notice, they got 7 days to comply. So, not to be too technical about it, but, 8 or 9 or 10 days later, you'll want to, go see if they've now complied with your park rule. And often cases, determining whether or not they've complied is pretty easy, right? I mean, you can walk by their home and you can figure out if the weeds are removed, if they're no longer hoarding, if the homeowner and their family cleaned up all the boxes out of the carport and the carport is now very, very clean. And you can just see that. And great, and you go on to other things that you're busy with at the office. Other times it's not so clear. There's the classic case of what if you had a situation where the homeowner is yelling at a neighbor, violating a park rule that says, you know, don't yell at your neighbors or be nice to your neighbors or do not disturb your neighbor. And you write them up, and you're writing them up because they violated your park rule by yelling at a neighbor. But during that 7-day period, what if they don't yell at the neighbor anymore? Have they cured the violation? I mean, you wrote them up for a 7-day notice saying, stop yelling. If they stop yelling during the 7 days, have they cured? And if they have, then what happens 2 weeks later when they start yelling and getting into a fist fight with the neighbor again 2 weeks later? You know, this is where the 7-day notices, sometimes their usefulness is not very clear. And you'll want to discuss that with your attorney, because perhaps you and your attorney are going to evaluate this and say, well, the 7-day notice doesn't make a lot of sense sometimes. Why don't we add an additional grounds of causing a substantial annoyance to your neighbors? So it's just something that, again, I want to highlight. There are sometimes potential problems with determining whether or not someone has actually complied within the 7 days. So you'll want to go over that with the eviction attorney. We've had a lot of discussion at seminars that I've been at and a lot of discussions with my clients and about this topic about how many 7-day notices do I need to, should I do before I can evict with serving the 60-day notice. The answer is that the law technically requires that you only have done one 7-day notice. But if the rule violation is very minor, sort of, you know, walking the dog in the park without a leash on, even though the law requires me only to serve one 7-day notice, we're probably going to have a better case in court in winning in front of the judge when it's a minor violation, if we serve more than one 7-day notice. The law only requires one, but sometimes we really like to make a strong case for court. Sometimes we like to serve a second 7-day notice, and then some park communities have a policy that they will even serve a third 7-day notice. And the reason for that is because you're trying to show a judge later on in court that even though the law technically required us only to serve one 7-day notice, this park community, this park manager tried to go above and beyond what the law required. That this park manager, Your Honor, talking to a judge, that this park manager tried to do everything possible to work it out with the resident. And so I would be arguing to a judge and say, Your Honor, my park manager was only required to give one 7-day notice, but he went beyond the call of duty and gave a second notice to this resident. And in fact, she gave a third 7-day notice. But you know, Your Honor, after trying to work it out with this tenant three times essentially warning this homeowner resident to comply with the park rules, this homeowner is not getting it. And, you know, the park manager is on the front line, I would argue to the judge, and this park manager is responsible for the health and safety of all the residents in the park. And that we all have to comply with the park rules. And one person in our park community doesn't get to not follow the park rules that the rest of the residents have to follow. So that's the rationale. I had a case just 2 days ago in which the offense was pretty serious, and we really don't think that they're going to comply at all. And we kind of came down with doing two 7-day notices. The one 7-day notice to get them to comply. They didn't comply. And because it's sort of a serious offense and we didn't want it to drag on over the course of time for 3 notices, we elected to go with 2 notices, thinking that we can use the same argument to the judge that, Your Honor, we tried with 1 7-day notice, and then we tried again with a second 7-day notice. So again, different clients and different attorneys will be preparing their cases differently, and you might decide that it needs a 1 or a second or a third 7-day notice. Typically, you don't serve more than 3 7-day notices. Is there anything wrong or illegal with that? There isn't. I think that the problem with doing a 4th and a 5th 7-day notice is it might start looking like to a judge that you're essentially sitting on your hands, that you know that this homeowner is committing a park rule violation, but you're really sort of not doing anything about it because the park is just giving one notice after another without doing anything about it. So I would not like to see a file come into my office with, 15 7-day notices regarding the same thing. That the judge may not think very favorably of you if you were sitting back and just generating 7-day notices. The next step after you have served your 7-day notices, you have verified that they haven't complied within the 7 days, you have given them a second or third 7-day notice perhaps, and they still haven't complied, then the next step, of course, is to serve your 60-day notice. And the law does require that you be pretty fact specific in your 60-day notice. There's a statute under, it's right there in the middle of your screen. It's 798.57. And the statute says the management shall set forth in the notice of termination the reasons relied upon for the termination with specific facts to permit determination of the date, place, witnesses, and circumstances concerning that reason. So what the law is saying is that we're going to require you in your 60-day notice to be as specific as you can with why you're terminating their tenancy. Trying to put into your 60-day notice the date as to when something happened, on October 3rd, you were involved in a fist fight on the park premises next to the swimming pool. This was witnessed by other homeowners. And circumstances, the facts are that, you weren't allowed in that pool or your guest was not allowed in the pool, whatever the story is. And so we tend to also want to counsel our clients that before you even did the 60-day notice, earlier when you were doing the 7-day notice, it's generally a good idea that you put all of these specific facts in your 7-day notice. And the reason for that is that way you have your 7-day notice to refer to when maybe several weeks, maybe months, you're preparing your 60-day notice. You don't have to recreate the wheel. You don't have to recreate everything. You can say to yourself, oh, here are my 7-day notices. Oh, that's right. I've got a lot of detail in my 7-day notices. And what you say in your 7-day notices, you can, quite literally, copy and paste and put it in your 60-day notice. And then that way you're not forgetting and trying to rack your brain at the time of the 60-day notice and say, now what was it? Where were they standing? What was the date? I don't remember. And it's real difficult for you to prepare your 60-day notice. So put your specific facts in your 7-day notice so you can refer to that later when you prepare your 60-day. The 60-day is, like I mentioned before, it's one of those notices that have to be served by personal service or substitute service or service by post and mail. On this particular type of notice, the 60-day notice, you're not permitted to simply mail it. And for those of you that are unfamiliar with what I mean by substitute service is a process where you walk up to the mobile home, you knock on the door, and there's someone who seems of age, maybe someone who's over 18, maybe you've never seen this person before, but you can hand the copy to this person who answers the door. but you have to go back to your office and you have to place a copy in the mail and mail it to the homeowner. So the idea is substitute service. You gave it to some person at their home, plus you came back and gave them a copy in the mail. So let's talk about the other grounds. We spent a lot of time on rule violations because that's a little bit more complicated. But separate and apart, completely separate and apart from evicting someone for violating your park rules, as a separate and independent grounds for evicting, you could just evict someone for causing a substantial annoyance to other residents or homeowners in your park. And the statute says, here in the middle of your screen, the statute says, I can evict someone based on, quote, conduct by the homeowner or resident upon the park premises that constitutes a substantial annoyance to other homeowners or residents. So the substantial annoying needs to be done on the park premises, and it involves you proving that the homeowner or resident substantially annoyed another homeowner or resident. The law does not say what a substantial annoyance is, and I don't believe there's been a lot of case law that's been developed in the court system where judges or the Court of Appeal have come out and said, we think substantial annoyance means X. So substantial annoyance is going to be a phrase that's going to be dealt with in court between the lawyers and the clients and the judge. Obviously, it's something more than an annoyance. It's something more than just, probably a minimal annoyance. The statute came out and said it's got to be a substantial annoyance. A substantial annoyance, I think most lawyers feel that discharging a firearm in the middle of the park, scaring everyone to death, would clearly be a substantial annoyance. And then the fact patterns, they run the gamut after that. And then there might be some things that you think, well, one neighbor is slightly annoying another, and we have to evaluate that and see if we could make a case in court in front of the judge that this conduct really, Your Honor, is a substantial annoyance. One thing to keep in mind is that the substantial annoyance grounds technically does not require service of a 7-day notice. So just keep that in mind. You might end up going straight to a 60-day notice based on a rule, you might do a 60-day notice based on substantial annoyance only, where technically you didn't need, because of substantial annoyance, you didn't need to serve a 7-day notice. The issues that lawyers have in court and working with park managers about the substantial annoyance grounds is if the statute is saying that we have to prove to a judge that the conduct substantially annoyed someone else in the park, another homeowner in the park, then do we need to have that other homeowner in court to testify? Essentially have that other homeowner testify in front of the judge that, hey, I live in the park and I was substantially annoyed. That's problematic because obviously the residents in our parks, they are our customers and our clients, they are our residents, they pay the rent, and a lot of homeowners and a lot of residents who might have been substantially annoyed may not want to get involved. And then it's a bit of an awkwardness, you needing to get a homeowner to come to court and yet that homeowner doesn't want to get involved. So that's some of the issues that you want to talk with your park manager and your park attorney and your district manager is if we can get this person out for causing a substantial annoyance, how do we prove that in court? And when we say, how do we prove that? What is our evidence? And is it going to require bringing other homeowners into court? And so those are some of the issues that you'll want to think through because sometimes there are going to be other people in the park that don't want to be involved, they don't want to cooperate, and they totally don't want to go to court and testify on the park's behalf. Very briefly, I think I've been talking, the second time now for about 45 minutes. We just have I think 2 slides left, and let me finish up here. Another option besides evicting someone, I just want you all to remember, is that the mobile home residency law does give us another option, which is not to terminate their tenancy at all, let them stay in the park. But when they are chronic rule breakers and they've continuously or reoccurringly violated a park rule, we can file a petition in court, and the statute says within 15 days after filing the petition in court, we can go to court and we can get a court order ordering the resident to comply with the park rule. The court order is called an injunction. And if you file a petition in court to get the injunction and you win and get the injunction issued, typically we say in the injunction order that the resident has 30 days to do whatever they're not doing, such as maybe cleaning up the boxes in their carport when they're hoarding. And if you go through that process, you are entitled, and you prevail, you are entitled to recover your attorney fees under the MRL for the time your attorney spent in preparing and going to court on the petition. Oftentimes these petitions are very useful, so you want to keep them in mind. There are occasional cases, I've had cases where a park manager had a resident in the park for perhaps 5 or 10 years, a good resident in the sense that he did not bother other people and he always paid his rent on time. But he was one of these people that was a hoarder and just really had a difficult time, could not clean up his carport, could not enlist the help of his family members to help him clean his carport and get the boxes removed. So we, instead of evicting this type of tenant or this type of homeowner, the park owner decided to have our firm file a petition with the court, to go to court and have the judge take the bench and issue an order ordering the tenant to remove the boxes from his carport. And the homeowner did comply with that order. The homeowner was actually at that point standing in court in front of the judge. This particular homeowner was very embarrassed by the whole process. He didn't cop an attitude at all in front of the judge. So we were able to get, at the end of the day, some compliance from this particular homeowner without having to evict this homeowner. These injunctions, if you go and get one in front of the judge, by statute, they last 3 years, and at the end of 3 years, the law says you're entitled to go back and get it renewed. And if you do go get the injunction and obtain that and get some compliance, the getting of the injunction does not legally preclude you from doing something later on, like evicting them. So if you get the injunction, you can still evict them later on. I was asked, well, actually it's this slide and I think one other slide, and then we'll move to questions. I was asked that could I speak for a moment on the rules applicable to RV parks, recreational parks. When you have a recreational vehicle park, that park is generally governed not by the mobile home residency law, but by a different set of laws called the Recreational Vehicle Park Occupancy Law. But in that RV law, they have a similar provision that's very similar to what we were talking about today, which is they have a provision that says that if you have a resident in your RV park who's lived in your RV park for 9 months or more, then you can evict that person similarly for violating your park rules or causing a substantial annoyance to other residents. And yes, the RV law is similar with respect to violating park rules. They do require you to serve a 7-day notice. So it's very, very similar when you have a resident there who's been in the park for more than 9 months. Keep in mind, however, that if you had what we call a tenant living in your RV park for less than 9 months, but more than 30 days, then they can be evicted without any cause whatsoever. You don't have to say, I'm evicting you because you violated my park rules, or I'm evicting you because you caused a substantial annoyance to other residents in the RV park. You can simply serve them with a 30-day notice that doesn't specify at all any cause or the reason why you're evicting them. That's just the way they do it in RV parks. They figure with people that are living there less than 9 months, will permit their eviction just by giving them a 30-day notice. And then finally, if they've been there less than 30 days, they're technically considered an occupant. And if you go through all of the hurdles you're required to go through, it's possible to remove an occupant based on a 72-hour notice, where the sheriff comes out and removes them. And if you do that process correctly on occupants who've been in your park 30 days or less, you need not resort to the court system, and you don't have to go through the eviction process at court. A few words, and I think this is my last slide, is that someone was asking me, well, could I please talk a little bit about the crazy COVID-19 and all of these eviction moratoriums that we see in the news. What's important to understand about the moratoriums is that currently we have moratoriums on various levels. We have them at the federal level, at the state of California level, and you could have moratoriums at the county or the city level. So what you'll want to do is go through with your district manager about whether or not the federal moratorium, the state of California moratorium, or if there is, and there may not be one, but whether or not there is a county moratorium or a city moratorium where your park is located, because you'll want to consult those moratoriums and make sure that you comply with them. So far, and it's kind of a hodgepodge in California, different counties and different cities are sort of copying and pasting each other's moratoriums, but then each moratorium tends to be a little bit different. And we're finding that some of these moratoriums do prevent you from serving an eviction notice, while other moratoriums don't really prevent you from serving the eviction notice. They simply sort of put a hold on your case after you filed the unlawful detainer eviction case in court. So the moratoriums are sort of holding up these evictions in different ways. So you'll want to make sure you do a thorough review with your attorney of all the moratoriums that may apply and make sure you comply with those. I think that's it. Thank you very much for your attention. I think right here under areas of practice, I just beefed up our bullet points here of different practice areas that we do here at Rudderow Law Group. So I do appreciate your attention. And Chris, do you want to see if we have any questions that maybe I can answer before we all log off?
Let's see. So we have questions and they voted them up. So whatever ones has the most votes have the most interest in getting answered.
Okay, great. Well, I've got like 4 questions here. So real quick, I've got a question that says, can we get a printout of these notices for future? And the answer is yes. I'd be happy to give you a form. It'll come with our usual disclaimer, of course, that you need to review your notice with your attorney, and one size does not necessarily fit all. But if you're interested, why don't you give me a call or send me an email, and so we can see what notices you'd like copies of. Second question, if the post office only delivers to our office, how do we get it to the resident? If the post office only delivers to our office. That is a good one. Typically, I haven't had that issue. I've had the post office go down the street and put it in each individual's mailbox. I assume that people have a cubby hole inside the park office. I assume that all the residents are not just getting mail to the park manager on that park manager's desk. So if you put something in the mail and the postman then comes back to the park and puts it in a cubby hole, where they receive their mail, I think you're fine. I think you probably should be able to, show that you complied with the proof of service requirement of sticking it in the mail. Next question, should it be noted in subsequent 7-day notices that this is the second or third 7-day notice within a certain period of time? Great question. As a lot of you are aware, putting down whether or not this is the first or second or third notice is required in other notices, such as the 3360, the 3-day notice to pay rent or quit. It's not required in the 7-day notice, but generally, do I think it's a good practice to put down this is your first or second or third? I think it's a great practice. I think that it shows the resident, oh my God, this says second notice, I better take this seriously. I think that when you have notices that say this is my first, second, or third, that it shows it's easier for the judge to handle all those various notices, because when the judge is in court on the bench, the judge is going to have a variety of documents, either on the computer screen or on his or her desk. These 7-day notices may all look the same to a judge. So if our 7-day notices say, this is my first one, this is my second one, this is my third one, it's generally easier for the judge to follow along in court about what the manager did. And finally, our last question.
There's actually one below that.
Okay. Let me do this. 2 more questions. Next question, should it be noted in subsequent 7-day notices that this is the second or third? Oh, wait, I think I dropped. I'll go back up. I already answered that question. What if the substantial annoyance is caused by a guest or family member of the homeowner, not the homeowners themselves? The answer is that the mobile home residency law is being more and more revised to have provisions in it that say that when it's the guest that is violating a park rule, that the park rules that the guests violated are going to be imputed to the homeowner, meaning that the law is going to say if the guest committed a rule violation, we're going to deem it as if it was a violation of the rules by the homeowner himself. And so you'll want to look at that issue with your attorney, but generally speaking, under the law, there is a route for the lawyer to make out a case where the lawyer can evict that homeowner when it wasn't the homeowner, but it was the homeowner's guest that was causing the problem. Do you think I've done all 4? Was there one more?
And then if they're upvoting them, they'll move. So that might have been why.
Maybe scroll down. Yeah. So let's see if we have 1 more, 2 more. 2 more.
Ooh, looks like we're getting more.
I'll just answer 4 more questions real quickly so we can all get on with our day. Do you recommend having the lawyers draft or look at the 7-day notice before sending it out? Absolutely. I think that's a great idea. We do that here at my firm every day, is we have 7-day notices that perhaps the park manager looked at or prepared and wants another set of eyeballs. And hopefully we can help add a couple things to the 7-day notice to make them great 7-day notices before they're served on the resident. Are Orange County courts accepting filings now for regular residential UDs, not mobile home or RV parks, even if not hearing them? The answer is, it's interesting. I've been attending some webinars of my own where I'm the attendee. There's been some webinars put on by the presiding judges at the courts, and I attended one webinar put on by the presiding judge of the Orange County Superior Court. And basically what he said was, look, you can electronically file something with our courthouse, but our staff is gone. We only have about 10% of 15,000 people that are employed at the courthouse who are still in the courthouse. So while you can electronically file anything you want with the court, there is no human being over there in the court system right now who's handling your court filing in the queue, who's not handling your electronically filed court thing. They still won't give dates as to when they're going to reopen the courts. I've heard different dates, maybe June. Hopefully it won't be July. But stay tuned on that. I think what they're all doing is what we're all trying to do, figure out how we can all go back to work. When that happens, there's going to be a tremendous backlog of cases that have been electronically filed since probably, mid-March. And it's going to take time for the courts and the staff to come back to the courthouse and catch up on all the electronic filings. Does Orange County now prevent from serving a UD notice because of moratorium? I don't believe so. If you want to check back with me and email me a specific question, I think your question is, does the County of Orange have a rent moratorium? And I'd have to double check, but I don't think they do. I think we've been analyzing different cities. I think like City of Santa Ana has one, and I don't think the county has, but I would have to double check on that. And then is there one last one by this client or not? No?
No.
Just a thumbs up?
Yeah, it just looks like.
I just got a thumbs up from one of my clients.
Yeah.
But that's, I don't think he stated a question. Again, my apologies for the technical difficulties today, but I think that this worked out great. I know we got started a little bit late. Have a fantastic day, and please call or write or email if you have any questions. Thank you very much. Bye-bye. Stop. Take me out of audio.